Welcome. We're about to get started. Hopefully we've got folks who are zooming in online as well to join us. But I appreciate you all being here. This is the second session of this fall's Education Policy Colloquium Series, sponsored by the Program on Education Policy and Governance. My name is Jim Pizer. I'll be your host for the day, and I'm an academic visitor here at the Kennedy School, and it's an honor and a privilege to work with Paul Peterson and Marty West at PEPG in order to put this colloquium series on, and as well as all the other programs that the center is responsible for. So in addition to today's event, we're going to have a series of these continuing through the fall semester, obviously, and into the spring, but most Thursdays at noon here in Taubman. So hopefully you can join us for those that are upcoming, and we'll let you know what's on the docket as soon as we have all those locked down. Today's session features Clint Bolick, who is a justice of the Arizona Supreme Court. And the title of Justice Bolick's talk today is The Establishment and Free Exercise Clauses of the First Amendment. And no, this isn't the Harvard Law School, so hopefully Clint will dumb it down a little bit for us here at the Kennedy School. But this is actually kind of an auspicious time to have a topic like this under discussion. It's the 100th anniversary of Pierce versus Society of Sisters, which was a tremendously important Supreme Court case upholding the right of parents to not send their children to public schools and importantly to send them to parochial religious schools, as well as the recent Mahmoud decision, which also has sort of significant implications for the topic of the day. So anyway, so this is very timely, even though we are sort of more of a general amateur audience when it comes to legal scholarship. Prior to joining the court, Clint Bolick was a highly visible and highly successful litigator in several public policy and public interest law organizations. Most notably as a co-founder of the Institute for Justice, which is where I got to know Clint many years ago. And actually, at that time, I was executive director of Pioneer Institute here in Massachusetts, and we formed a center on urban entrepreneurship, very much drawing on the work of Clint and his colleagues at the Institute for Justice. But in those roles, Clint has been a staunch advocate for individual liberty, economic empowerment, and educational choice. Earlier in his career, he served in Washington, D.C. with the Equal Employment Opportunity Commission and the Justice Department's Civil Rights Division. After Clint's comments, we'll have time for questions and answers. And if we've got folks online who are interested in commenting, please put your questions or comments in the chat, and we'll try to work you into the conversation as well. The conversation is being recorded, so Clint, probably more for you than the rest of us, but it's ultimately on the record. But with that, it's a privilege to turn the podium over, or you don't even have to grab to the podium. You can stay right where you are, to Justice Clint Bolick.
Thank you. Thank you so much for having me, Jim. It's so good to see you again, and Paul, to be with you. I just spoke to one of Professor Peterson's undergraduate classes and just had an absolute blast. Last year, when I spoke here afterwards, I'm not sure you know this, I was mentioning it to Paul last night, but there was a lady who came about halfway through who's in the adult education program here at Harvard. And afterwards, she came up to me and she said, I just wanted to let you know that I have a daughter who went to private school in the Cleveland School Choice Program, and she went on to go to Harvard and Yale and is now a lawyer in Phoenix, and I have actually gotten to know her. And you know, it's so rare, whether in academia or in the law, to see the human consequences of the decisions that courts make and the cases that are litigated. And it was just such a wonderful experience to know that that program has produced just some really, really great results like that. You were mentioning dumbing things down, and I have to say the Establishment Clause and the Free Exercise Clause are extraordinarily complex legal issues, but only because they have been in the hands of lawyers and judges. If you read the words of the Constitution, and I will begin with those words, they're not all that hard. And it's because we've gotten away from the plain meaning, the plain original meaning of the words in the Constitution that things have become such a horrible mess. I am a legal textualist, which means that I interpret constitutional provisions and statutes according to the common understanding of what the words meant at the time they were agreed to. And so I hope that my opinions are not nearly as difficult to fathom as some of the U.S. Supreme Court decisions that I will share with you today. So in Arizona, our judiciary has what's called a merit selection system, where anyone who meets the qualifications to be a judge can apply for any opening. You go before a citizens commission, they nominate X number of candidates that go to the governor. And I was the first appointee to the Arizona Supreme Court by Governor Doug Ducey. And each governor has his or her own style of interviewing candidates or not interviewing candidates. And I was the very, very first judicial candidate to go before Governor Ducey. So I had no rumors or anything about what I was in for. And I went in, and fortunately I knew him, so it was a comfortable situation. But he sat down and smiled, and he said, well, we have 75 minutes and I have 50 questions, and I'd like to get through as many as possible. Like, oh my gosh, 50 questions. And one of his questions, and holy cow, when he asked it, I'd never been asked this question before. And the moment he asked it, I just absolutely loved it. And he said, which is the more important of the religion clauses in the First Amendment, the free exercise clause or the establishment clause? And I had to think about it because I'd just never been asked that before. And I would wager, there were 7 of us being interviewed. I would wager that the other 6 all said, well, they're equally important. They're both part of the Constitution. And so, of course, I would give them equal weight. I did not answer that way. And I want to read the language of the religion clauses of the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Again, the Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And I answered that it was the free exercise clause that was the more important of those 2 things. And the reason is that the first language is, in my opinion, very, very narrow. It simply prohibits Congress from establishing a religion. And if you look back historically, this was an issue. Here in the United States, some of the states created official churches. And you note that language did not disturb their ability to do so. It only forbade Congress from establishing a religion. And when you think about in the year, well, let's see, this was 2016 when I was appointed. In the year 2016, it's simply a non-issue. No one's talking about Congress establishing a national religion, and hopefully they never will. And as a result, if you look at the plain meaning of the language of the Constitution, this is a provision that probably has no meaningful impact. And yet we know that that's utterly and totally not true, because there's hardly a year that passes that the U.S. Supreme Court does not decide at least one, if not more, cases under the Establishment Clause. But prohibiting the free exercise thereof. We are an incredibly religiously diverse country, and we have always been, even long before we were a country, we were a beacon of religious liberty. And so, to me, those words have incredible relevance today, and have literally at every minute since our nation began. For about 150 years, though, state constitutions for most religion issues were the only show in town. It really didn't matter what the federal constitution said about religion, because the Bill of Rights was a constraint only on the power of Congress, not on the power of the states. And of course, every state constitution has a protection of the free exercise of religion. In fact, the federal protection traces to the Virginia Declaration of Rights, in which freedom of religion was incredibly important and central. And most state constitutions also have a prohibition against the establishment of religion as well. Now, that was the fact that the Bill of Rights pertained only to the federal government was supposed to have changed with the adoption of the 14th Amendment after the Civil War. The period between the founding and the Civil War proved that states who were intended to be our primary guardians of freedom were not always very good at it. Quite the contrary, many states routinely violated the most basic constitutional rights, even in their own state constitutions. And as a result, when the 14th Amendment was adopted, it was meant to essentially nationalize the protections of the Bill of Rights against the states. But the U.S. Supreme Court held, nope, that's not, in 1873, they held, nope, the Bill of Rights still does not apply against the states. And only starting in the 1920s did the U.S. Supreme Court do what is called incorporating specific provisions of the Bill of Rights against the states, so that if the state violates, for example, freedom of speech, you can file a lawsuit under the federal constitution against the state or your city. And in fact, freedom of speech was the very first protection guaranteed against the states. This has been a process that has continued until the present day. Fairly recently, this century, the court interpreted the Second Amendment's right to keep and bear arms against the states, and had previously rejected that notion. So for a long time, freedom of religion, if it wasn't protected by your state constitution, it wasn't protected at all. So this began to change over time. And in fact, state constitutions became even more restrictive with a series of amendments following the Civil War called Blaine Amendments. And these amendments were pushed by a United States Senator who ran for the Republican nomination for president, a guy named James G. Blaine. He was very, very nativist. Immigration at that time was perhaps an even more divisive issue than it is today. But Blaine did not like the fact that immigrants were bringing their language and their religion to the United States. At the time, public schools were Protestant schools. They were not secular. They were religious schools, but they were run by Protestants, with the Protestant Bible being taught in these schools. And Blaine wanted to keep it that way. And Blaine proposed a national constitutional amendment that would prohibit public funds to be used in aid or support of sectarian schools. Today, the word sectarian means religious. At the time, it meant Catholic. And so this was designed, it's like, nope, all the money goes to Protestant schools, no money goes to Catholic schools. So he failed to get a national constitutional amendment to forbid this type of aid, but he succeeded in getting state constitutional amendments passed in roughly 2/3 of the states that would prevent this sort of aid. So we begin the battle for school choice and parental autonomy in the 1920s. And there were a number of cases during that time regarding the prohibition against teaching foreign languages in the public schools. But most importantly, in a case that Jim mentioned, Pierce versus Society of Sisters, which just celebrated its 100th anniversary, and a very, very important case. In Pierce versus Society of Sisters, the Ku Klux Klan dominated politics in Oregon and elsewhere around the country, and they proposed that all children in K-12 education could go only to public schools. And the idea was to put private schools, and in particular, Catholic schools, out of business. And so this issue goes to the U.S. Supreme Court, and there are two plaintiffs. The first plaintiff is a Catholic school run by an organization called the Society of Sisters. It dates back to 1849. Although it's a Catholic school, its children include Jewish children, Muslim children. Just like Catholic schools today, they are not homogenous religiously or otherwise, but they're going to be wiped out if this law is upheld. They are joined, and that is a girls' school. They are joined by a boys' military academy that is secular, but they too are going to be put out of business if this law prevails. So they go up to the U.S. Supreme Court, and now looking at the case from hindsight, one would say, well, their primary argument, especially for the Society of Sisters, is going to be religious liberty. After all, they're a religious school. They are targeted because they are a religious school, and they are violating the right of free exercise of religion. But that argument is not available to them. Why? Because the free exercise of religion has not yet been incorporated against the states. So there is no federal, in 1925, there is no federal constitutional right to free exercise of religion as against the states. So instead, they make a novel and radical argument, and that is that the protection of life, liberty, and property under the Due Process Clause of the 14th Amendment includes the right of parents to control the education and upbringing of their children. And the United States Supreme Court decides by a 9-0 vote that, in fact, they are correct. that the entire history of our country, dating back to the common law in England, establishes that parents are the primary guardians of their children's education. And in so doing, they create or they recognize a right that does not just protect religious people, it protects everyone. And the language from the decision is just majestic. The court declares that the child is not the mere creature of the state, that those with the responsibility and duty of raising them also have the authority to make basic decisions on their behalf. Many of the cases from this era have been overturned by the U.S. Supreme Court that were decided under the Due Process Clause. This case and the other education cases from that period not only remain good law 100 years later, they are bedrock constitutional principles. And in fact, years later, when my colleagues and I are defending school choice programs, our opponents are arguing that it's a violation of religious establishment. And we are saying it is a vindication of Pierce versus Society of Sisters and Brown versus Board of Education, which establishes the right to equal educational opportunities. Well, in any event, a lot happens over the next century and leading us to where we are today. After the conservative court that decided Pierce versus Society of Sisters, within about a decade, the court has switched from a conservative court to a liberal court. The FDR court followed by the Warren court. Very, very liberal courts. And interestingly, one of the things I teach constitutional law, and one of the things I love pointing out is how conservatives and liberals switch sides on issues very frequently over the course of American jurisprudence. So the FDR court, and in particular the Warren court, takes a very expansive view of the Establishment Clause. And the Establishment Clause becomes known, and this is a slogan. This is not constitutional language, but it is taught as if it is constitutional language. The Establishment Clause becomes separation of church and state. Almost everyone, if you ask, is separation of church guaranteed in the US Constitution, they will say yes. But when you look at the actual language of the First Amendment, it doesn't, in my opinion, it doesn't come close to establishing what the court ends up calling a wall of separation between church and state. And during this time, the court strikes down a whole variety of state aid to religious schools and other types of programs like that. But the liberal court also takes a very expansive view of religious liberty. That is opposite of today, where most of the liberal judges take a narrower view, but at the time they took a very expansive view. And one of the cases, two of the cases that they decided are particularly pertinent. The first was a case called Wisconsin versus Yoder, in which the state of, it wasn't Pennsylvania, even though I always think of Wisconsin versus Yoder. All right, that's an easy one. The state of Wisconsin requires education in a school until the 8th grade. The Amish, as a matter of religious liberty, believe that above a certain age, children should be taught at home. And the US Supreme Court, a very, very liberal court, says, as a matter of religious liberty, the Amish must be exempted from this otherwise applicable law. And in a later case called Sherbert versus Werner, they established the test that if a law weighs heavily on fundamental core religious beliefs, that the law must make an exception for those who hold those beliefs. The Sherbert case is overturned by a conservative court in a case called Smith versus Employment Division versus Smith. And there, this deals with benefits and the objection of people working on the Sabbath and who want unemployment and they're unwilling to work on the Sabbath. And there, the court, in a decision joined by Justice Scalia, says that if the law is neutral as to religion and imposes only a minor inconvenience on religious beliefs, it will be upheld. And ever since those two decisions, there's been a war between the Sherbert test, which establishes a presumption in favor of religious liberty, and the Smith test, which has a presumption in favor of neutral government laws prevailing over free exercise of religion. Ironically enough, the sides have switched in these cases. It's now the conservatives calling for the Sherbert test, the liberals calling for the Smith test, but nonetheless, the battle has continued. So Congress gets into the act, and it passes a law called the Religious Freedom Restoration Act. And it restores, and I apologize for the complexity of this. It's not my fault. I'm trying my best to cut through this, but the Religious Freedom Restoration Act purports to restore the Sherbert test, that is the test that is more favorable to religious liberty. That law gets struck down under by the Supreme Court in a case called City of Bernie, where the court says, the Congress doesn't get to define the scope of the Bill of Rights. We do. And the Congress has changed what we've said, and they're not allowed to do that. So the Religious Freedom Restoration Act is struck down, and then about half the states pass their own version of the Religious Freedom Restoration Act. So whether the Smith rule applies or the Sherbert rule applies depends on where you live. Arizona passed its own Religious Freedom Restoration Act, and so it's more protective of religious liberty. Other states did not, and so it's less protective, and this is called federalism. Where you can move from one state to the other to the next, and your liberties will be affected. With regard to the separation of church and state, the liberal court came up with a test that, in my opinion, was very, very aptly named the Lemon test. And this was a very restrictive test regarding state aid to religious organizations. And it made it very, very difficult for school choice type programs to prevail. And this was when I was defending school choice programs, the Lemon test was my kryptonite. This was the test that was always quoted back against us. It was the test we always had to meet, and it was very, very difficult. Well, the court moves from liberal to conservative in the 1990s. And since that time, the more conservative court has dramatically decreased the scope of the Establishment Clause and increased the scope of the free exercise clause, and that is where we are today. One of the big cases was the case that I litigated regarding school choice, and that was a case in 2003 called Zellman versus Simmons Harris, which upheld the Cleveland school choice program. And the court said, with regard to aid to religious schools, that so long as the aid was indirect, that is, that it was sent to religious schools not by the state, but by the individual choices of individual parents. And so long as there was a range of choices, not just religious schools, the program would be constitutionally permissible. This case, I cannot tell you, it culminated 12 years of litigation, 16 different cases, all of which my colleagues and I litigated. This case was very difficult to win because of the jurisprudence that we inherited, and we won it by a single vote, 5-4. The dissenters said we are going to see riots in the streets. We are going to see religious turmoil like we've never seen before. Still waiting for that to happen. It hasn't happened. It's not going to happen, but a lot of kids are getting a better education as a result of that decision. But since then, a number of other cases have been decided that have, in many instances, gone far beyond what I ever could have predicted. There was a case that went up to the U.S. Supreme Court, the American Legion case. And if any of you have ever been to Prince George's County, Maryland, especially at night, you're driving around and you see this square surrounded by a traffic circle with a blazing cross, not on fire, but just lit up in the night sky. This huge cross. And I remember the first time I saw it, I'm like, wow, that's an Establishment Clause violation under the U.S. Supreme Court precedent. And in fact, it was challenged as a violation of the Establishment Clause because it's the county that owns it and that keeps it up. The U.S. Supreme Court said that that was permissible. And the reason they said that it was permissible is because of history and tradition. It started out as a World War I memorial. It was erected and maintained by the American Legion in the first few decades. And over time, they couldn't afford it anymore, so the county took it over. And the court reasoned this had a secular purpose to memorialize war heroes. That history and tradition cleanses it of an Establishment Clause violation. I'm not the biggest fan of that decision because, as the dissenters pointed out, how many years does it have to be? 50, 35, 100? When does the Establishment Clause violation go away? But nonetheless, that was the decision in the court. Another case that probably everyone has heard about is the Kennedy versus Bremerton decision, known as the praying coach decision. And this involved a public high school coach who after football games would pray with his students. He didn't require them to pray, but most of the students gathered around. Now, before this decision, the court took a very dim view of anything in K-12 education involving prayers or religious activities, saying children are so so susceptible to coercion, so susceptible to the influence of their teachers, that this might not be a voluntary activity. The court changed that view and said, we see no evidence of coercion here. It is totally free for the coach. The coach is totally free to pray on his own time. And if people want to join him in their own time, that is totally permissible. The two features now of Establishment Clause jurisprudence, I believe that the Lemon test is dead, even though the court has not said so. But the two primary criteria that the court now applies to the Establishment Clause are coercion and non-discrimination. Coercion, if the government is coercing religious activity, for example, it requires its students to pray, or it has a prayer every day as a matter of course, and a particular denominational prayer, it's going to be unconstitutional. But voluntary prayer reading, voluntary reading of the Bible, or any other religious text is going to be permissible. And non-discrimination, this has been the sea change in Establishment Clause and Free Exercise Clause jurisprudence. The court has held that the state cannot discriminate in favor of or against religion. And that is where things have really changed. So most recently, so the Zellman decision, which upheld the voucher program in Cleveland, had the question before it, is it permissible to include religious schools among the range of educational options in a voucher program? 20 years later, in a case called Carson versus Macon, the court had a very different question before it. Is it permissible to exclude religious schools from a range of educational options? And the court, by a 6-3 vote, decided no. If you have a school choice program that includes private schools, you may not exclude religious schools, even if you have a Blaine Amendment in your state constitution. If that Blaine Amendment forces you to discriminate against religious schools, it is impermissible. And so what happened in Carson versus Macon, Maine and Vermont, in many of their communities, don't have public schools at all. They do what's called tuitioning. The kids who would go to public schools receive a tuition grant that they can use in any school, a neighboring public school district, a private school, even a school in Canada, they will pay for. The only schools they wouldn't pay for were religious schools. And so it was the students and the parents that challenged this, and the court struck that down as discrimination. Finally, the most recent case involved charter schools. And in Oklahoma, a religious school applied to become a charter school. Charter school is typically a private organization that receives a state charter to become a public charter school. And applying the Carson decision, this school challenged the exclusion of religious schools from charter schools. The case goes to the U.S. Supreme Court. Justice Barrett recuses herself, and the court deadlocks 4-4 on that issue. We don't know who the four on either side are. Oddly enough, they did not name themselves, which is very, very ironic. Will this case come back up from a different state? Yes, Antonio has the right answer. Yes. Will that presumably be a case in which Justice Barrett will not recuse herself? Yes. And so at some point, we will have that issue decided by the U.S. Supreme Court. And then finally, last, the issue comes full circle, and the United States Supreme Court decides to celebrate the 100th anniversary of Pierce versus Society of Sisters in a case called Mahmoud, which is a case from Montgomery County, Maryland, where the school board has an opt-out program for students, for parents who object to certain materials that are being taught in class. Then they decide, you know what, this is way too much trouble. We're going to stop the opt-out program. Well, in this case, a Muslim family challenges LGBTQ classroom materials. They apply the Pierce decision, and now they get to argue free exercise of religion as well. And the court decides, yes, parents do have the right under the Constitution to opt their children out of classroom materials with which they object. So where does that leave us with the Establishment Clause and the Free Exercise Clause? Well, for me, it leaves my head spinning. I would not have predicted any of the recent cases based on past jurisprudence. If I were just reading the language of the Constitution, none of this would surprise me, but we departed so far from the language of the Constitution that this zigzaggy course of cases was able to occur. But I think that the Lemon test under the Establishment Clause is dead. And I think that the Smith test is probably also dead, even though the court has not said so. So this is probably the year 2025 is probably the year for the greatest constitutional protection for free exercise of religion in our entire nation's history. And it is probably the least constrained with regard to the Establishment Clause as it has been since the mid-20th century. And given that at least two members of the Supreme Court, Kavanaugh and Barrett, care probably more deeply about this area of law than any other, and they are both pretty young, I think that this will be the trajectory that we are on for a while. And as someone who teaches constitutional law every fall, I am constantly having to update my materials because this is an ever-changing area of law. But I think that's where we are at the moment. It is either a cause for celebration or lamentation, depending on your own views. But hopefully, given the complexity of the case law, that is a relatively clear summary of where I think we are in this area of the law. And I really thank PEPG and the Kennedy School and these fine gentlemen for inviting me to speak. Thank you.
Thank you so much for that. You didn't dumb it down, but you made it, at least I could understand it. Hope, and I'm sure everyone else in the room, clearly did. Maybe following up a little bit on the Mahmoud case. First of all, to understand whether the decision relied mostly on a freedom of religion argument or on the sort of due process parents have a right to their child's education, which meaning in particular, is it because the material in question violated some religious commitments or convictions, or it would just violate a parent's rights to decide these decisions for themselves?
So, so this is going to require me to lapse into legal jargon, and I apologize for
I
that.
apologize for asking the question.
No, not at all, not at all. It's a great question. It's a very, very important question. So it was mainly a freedom of religion case, which means that it pertains primarily to religious objections to the materials that were being taught. The reason, but everyone, the liberals and the conservatives, every chance they get, they cite Pierce versus Society of Sisters, they cite Meyer versus Nebraska, and the other cases, the other parental cases from that era. So it's still good law. The reason I think they went with religious liberty over parental liberty is because they are trying to get rid of substantive due process. Substantive due process was the judicial creation of substantive right, and this is where I'm getting jargonistic, and there's unfortunately no way to avoid it, where the court in the 20s and before then derived substantive rights under the Due Process Clause before the incorporation of the Bill of Rights. Substantive due process initially was used to protect freedom of contract and parental liberty. Then when the court shifted to the left, substantive due process was used to recognize a right to privacy, a right to abortion, and a right to same-sex marriage. The conservatives don't like that. So they are now trying to discredit the whole notion of substantive due process. And as a result, I think we will continue to see, and the other way they could go is to decide the same issue as a matter of free speech and freedom of association under the First Amendment. And I think we may see the same rights protected over time, but the court is struggling with itself. Substantive due process was a conservative creation that was applied by the liberal court in liberal directions, and that the conservatives on the court desperately want to get rid of that without throwing the baby out with the bathwater.
So that is sort of the backdrop. The prior cases that you described were mostly about parents choosing which school to send their child to, which obviously allowed for different kinds of schools, which different approaches both to education as well as to some of these sort of broader social/religious issues. But now with Mahmoud, it seems like parents are being empowered potentially to have veto rights for their child on almost anything that could be in a curriculum. And also in doing so, perhaps requiring schools to provide more structure and advance notice to that curriculum so that parents have the option of opting out. Anyway, this sounds like chaos. And I'm just wondering if you see in the way Mahmoud was decided any sort of limits or constraints around what parents for religious reasons or other, but in particular for religious reasons, might require of their schools.
So I do see a pretty clear line of demarcation, and this even goes back to the Pierce cases where they said the state unquestionably has the power to require education. And in subsequent cases, it's held they also have the state also has the unquestioned power to establish basic curriculum requirements. So if a parent came in and said, you know what, we don't believe in math. It offends a core tenet of our religion. If there is such a religion, I would join it so that I could have gotten out of math. But they're not going to recognize that because there's no question that the state has a compelling interest in providing basic curriculum requirements. And in fact, they even do in most states for private schools that receive no public funding and that sort of thing. But for specific elements of teaching within that curriculum, and it could be, let's say there's, well, I can't think of a good hypothetical right now, but
Well, the one I can think of is, let's say somebody objects to teaching the history of slavery and segregation in the United States in a way that makes it, does not give due attention to the extreme sufferings that were endured by a significant number of Americans, and downplays the role of segregation, which might be happening in schools in large parts of the United States today. And some parent group might say, I don't want my child subjected to that. So I want to opt out of the history offerings at the school.
So a couple of thoughts on that. So long as the right is religion-based, it probably wouldn't encompass that. If it becomes more speech-based, it probably would. But if the school said, okay, you have to read this history textbook, they wouldn't be able to opt out of history altogether. But I do think that Montgomery County's principal argument was exactly what you said, which is this will be chaos. I think we're going to see greater transparency requirements. And I think for the most part, and certainly sex education of any sort, or sexual gender identity types of instruction, they are, the first things that parents will be able to negate. And then, but I think it will be a relatively finite category of objections, because you do have to show that the book or the materials or the required course offend core tenets of your religion.
And you could, and I'll open up to questions in just a second, but this was sort of fought over elementary school curriculum. And to your point, there's probably less potential, except for the areas that were identified, probably less potential there. As you get into high school, when you're talking about physics and science and biology, you are running into areas where there are, certainly people with strong religious convictions who object to
even creationism. Would, I think, probably be a viable objection if evolution is taught as a fact. I think probably parents whose core religious tenets revolve around creationism would be able to, and those would be more advanced classes. Right. And there's a way to deal with that, and that is to make them electives rather than.
But this gets to the, so Massachusetts, as most other places, requires lab sciences or, the sciences in high school, biology being typically the most important. But most of them have standard science courses that include, discussion not only of evolution, but the age of the universe, and the Big Bang Theory, and all this other kind of stuff. But Mamu does seem to open up those to opt out.
Yeah, and again, it's you just articulated Big Bang Theory. So long as Big Bang remains a theory, it's probably sacrosanct. Mm-hmm. And here's another thing: the more choice that is available within the system,
the weaker those arguments become.
Yes, exactly. You can opt out with your feet. It's going to be really interesting. And again, I never would have predicted that we were so quickly where we are today. but I think there is still much more to come.
Any other questions?
Yeah. And do you mind introducing yourself?
Yeah, sure. I'm Sahar Atif. I'm mid-career at the Kennedy School,
Cool.
a student with a sort of legal background, but outside of the States. I was a lawyer in Sudan. So thank you, Your Honor, for this amazing session. It's very
Thank you
interesting.
thank you for enriching our experience.
Thank you. It caught my attention. It's very interesting what you were saying about the interview and the comparison between the question that you loved, and I loved it too, of the First Amendment versus the 14th Amendment. It's very interesting how you see the wide scope in the exercise rather than the establishment. And I'd like you to elaborate more because it's very interesting. Usually people will just go to the establishment
Yes.
or most of the people say they are equally, but this is really interesting view.
Yeah, I think that the safe answer was to say that they're co-equal, but I ended up on the court. So the governor must have been looking for for a different answer to that question, or other questions as well. It was quite an interview, and considering that a lot of the questions were about constitutional law, and a lot of lawyers don't think very much about constitutional law. I definitely felt like I had an edge there. But, to me, exercise of religion is a very broad thing. And, one of the cases that went to the United States Supreme Court involved animal sacrifice, which is not a mainstream thing. And generally speaking, the court would, and another involved the use by a Native American tribe of the drug peyote that was constrained, unsurprisingly, by federal drug laws. Exercise, in my opinion, is a very, very broad term, and it really protects minority religions and minority practices, which I think, was kind of the point of the Bill of Rights, was to protect the minority against the majority. And so because of that word, free as the adjective and exercise as the verb, I think that it's very, very broad. The limiting word there is prohibiting. It doesn't say regulating. The government can regulate the free exercise of religion. What it cannot do is to prohibit. But still, I think in its overall structure, it was meant to be a broad protection. And if you look at history, you will see that was kind of the point of our country in large part. And that was a revolutionary component of our Constitution. Whereas establishment of religion, it doesn't say favoring, it doesn't say subsidizing, it doesn't say, advancing, which is a word, the Blaine amendments use aid or support, far broader terms than establishment of religion. So to me, that's a pretty finite term. It came up in our class earlier today that Justice Thomas advocates removing that from the incorporation of the Bill of Rights because it doesn't protect an individual right. So so far that's been the view of one justice. Sometimes the views, as I can personally attest happily, sometimes the views of one justice become the views of a majority of the court. And it would not surprise me if this conversation largely disappears because that view prevails. Whether that's a good thing or a bad thing, I would leave to the judgment of others. But it's just I think the Establishment Clause evolved way beyond its narrow intended scope. And now the pendulum has swung massively back. And whether it should stop somewhere in the middle or keep going, I suspect the next 10 years are going to continue to be pretty interesting in this area.
Other questions?
Steve,
Would you mind introducing yourself?
I hail from a wonderful state where we have a fantastic Supreme Court. I'm
Where's
familiar with it. Has a lot of
I need to
cacti
move
and stuff
there.
like that. Yeah.
And Mexico?
There we go.
I'm from Arizona, along with Justice Bullock. And so to protect minority religions, yes, but jurisprudence does suggest that there's or define some threshold of your religion. And I was hoping you could say where we are with that, because I can't just create a religion today that says, to your math point, we don't believe in math, sort of thing. The court wouldn't give any deference to the legitimacy of that, which I've always found to be a somewhat dangerous enterprise for a court to get into the business of sort of what qualifies as a religion deserving First Amendment rights versus not. But I know that there is some definition, or there's some sort of working knowledge. And where are we on that?
So that is a really good question. And that happens, Stephen, to be a question that had personal relevance to me. So my wife, who you know, and I were planning to be married by my brother, who is a lay Buddhist minister, and presides over, I don't even know what Buddhist religious ceremonies are like, but whatever they are like, he presides over them. And when we submitted that to the Commonwealth of Virginia, the Commonwealth said, he doesn't have religious credentials, he's not allowed to do it. So we actually have two anniversary dates: the day on which we were married by Judge Douglas Ginsburg, and the date that my brother unlawfully married us, which means we get to celebrate twice, which is really kind of cool. But nonetheless, I didn't have time to sue. And if I had had time to sue, I have no doubt that I would have won that. You are absolutely right. The court has consistently ducked that question. And I think the way it's managed to duck it is by only granting review in cases where the religion is unquestioned, and as a result, that is, almost the elephant in the room. What is a religion? What counts? And the court, I think you're absolutely right that this is an incredible can of worms. And this also arose with conscientious objectors in the Vietnam War era, where it's like, well, does it have to be religion based? Can it simply be philosophically based? What if it derives from, a belief in God, but not a religious doctrine and that sort of thing? So the courts really have not engaged in this in any sort of manner that I could tell you this is the rule. Basically, they look to see how long the religion has been established, and they will go into the core tenets. They will say that the religious objector has to show us that there is a biblical basis for this. The closest our court has come to it when when we, in a case since I've been on the court, was our brush and nib case, where we had calligraphers who objected to providing customized wedding invitations based on their opposition to their religious objection to same-sex marriage. And there, mercifully, the city did not contest their sincere religious beliefs. So we didn't have to tackle that issue. And even though I'm not religious, I'll say thank God.
So following up on this discussion, if you pushed this point to the limit, the only solution would be to give every family a choice of school by giving them a certain sum of money, which would be spent wherever they wanted for their child's education, so that you could have the curriculum you wanted, or you could have the organization of the school the way you wanted, or whatever. And we're not too far away from that in Arizona in particular, because we have these education savings accounts. Is this a line of thinking going to become so pervasive that you could imagine education savings accounts becoming the universal mechanism by which the government provides for the education of the population?
Well, this is why the Kennedy School is the epicenter of education reform ideas, because you've just solved the constitutional conundrum here. But it's certainly, it's so ironic that, in the Zellman decision, the dissent predicted religious strife and warfare, essentially. They compared what was going to happen to what had happened in Bosnia and Northern Ireland. I mean, that's histrionic in the extreme. It's almost had the exact opposite effect. It's sort of like educational federalism, where if you prefer the values of another entity, you vote with your feet to do that. So I actually think it's been a depressurizing school choice has been a depressurizing situation. I lament a little bit, and this may surprise you and may provoke your ire, but I do think that we do.
Hard to provoke my ire.
Okay, all right. Well, I'll try my best. I do think that we are losing a bit of the civic unity that came from us all having a common education experience. Do I think it's worth it? Absolutely, I do. But I do think, we all used to read the same newspapers. We all used to go to the same schools, with some exceptions. And the kids in the neighborhood all had these common shared experiences. And I do think that there is a cost of that, and that it adds to what we're seeing with social media and that sort of thing of putting people more into bubbles. But I think the best way for the state to counter that is to require civics education across the board, and a core curriculum, so that at least we have a common educational basis. See, that's even on film now that I just.
Speaking of which, Michael, is there any comments or questions on the chat? Okay, great. I think we're pretty much done. Any sort of concluding remarks or benedictions given the conversation?
No, just thank you so much for coming out, and I love coming here, and hopefully I will be invited back.
Thank you very much.
Thank you.